An IP right represents a promise of economic exclusivity. All the investment made in R&D and setting up an IP portfolio are based on the expectation of a proper enforceability against third parties' infringement. The IP enforcement in the EU is usually managed through the civil courts. Only for trademarks literally massive infringement cases the IP owner, for cost reasons, tends to prefer the criminal way. Even if a patent, a trademark or a design received a grant certificate by a local or supranational office, like the European Patent Office for a patent or the EU Intellectual Property Office for an industrial design, its validity can be always challenged before a civil judge. From 1995, following the TRIPS agreement, the European Union imposed to all its member states to designate in their territories a limited number of specialized national courts of first and second instance. This was clearly aimed at generating the so-called predictability of the enforcement decisions for the evident dissuasive deterrent effect. The enforceability of an IP right may differ country by country. In Italy, it's possible to enforce any IP right even before grant, during the application period, while in Germany and China, for instance, it will be possible only after the grant. Especially in patent litigation, the civil proceeding is clearly showing a demanding task to discuss with a legally qualified judge technical issues related to validity and scope of protection and infringement. For that reason, usually the patent litigation involves the participation of lawyers and technical experts working in team in order to manage at the best juridical and technical subjects. In some countries, like in Italy, the judge usually appoints a court technical expert in order to define the technical arguments about validity and infringement. In an infringement lawsuit, the validity of the patent is normally questioned by supposed infringer, who tries to find new documents in the attempt to demonstrate that the enforced patent is not new or not inventive. In most of the countries, the validity of the patent and its infringement is assessed by the same judge, while in Germany, the civil judge is only competent for the infringement issue, while the issue of the patent validity shall be raised before an administrative central authority, the so-called Bundespatentgerichtshof. The legal framework for the IP enforcement is strongly harmonized within the EU by the Enforcement Directive of 2004. Such a directive, largely self-executive, harmonized the best practice within the EU on the IP enforcement. The civil enforcement as harmonized by the directive is based on two different options: urgent proceedings and ordinary proceedings. The urgent proceedings are characterized by the average duration of 3–6 months and offer the option to obtain a very effective solution. The aim is secure the evidence needed in order to demonstrate infringement and to collect the damages values. Obtain the seizure of the allegedly infringing goods still offered in the market and obtain an injunction against the alleged infringer to avoid the continuation of the infringement for the future. The ordinary proceeding is characterized by an average duration of 3 years in Italy, France and UK. In Germany, the duration of an infringement proceeding is usually 1 year, but the patent validity issues in front of Bundespatentgerichtshof may take 2 additional years. After having analyzed the IP arguments, if the judge will be persuaded of the infringement, the second important part of the proceeding is based on the damage determination. There are 3 criteria in order to define the damage claims: the lost profits of the IP owner due to the infringement, the undue profit collected by the infringer, the royalty value to be paid for the use of the IP asset stimulating a license consensus. The most common use is the royalty method, sometimes doubled in order to generate a deterrent effect. Any strategy related to the civil enforcement shall take in account the pros and cons related to each juridical culture. For instance, in general, British judges are more liberal, while German judges are more favorable to the IP owners.